Kansei, Raymond, Netzigasson, Notari Oscar, Egua, Nigari Doris, Netatoscan, National Center for Truth and Reconciliation. Hello, my name is Raymond Frogner. I'm the Director of Research and the Director of Archives for National Center for Truth and Reconciliation. I'm speaking to you today from Treaty 1 territory and the treaty territories and ancestral lands of the Anishinabeg, Anishinaabe, Dakota Oyate, the Nesulene, and the Hetoak nations. I also acknowledge this territory is located on the homeland of the Red River Métis. Directly north includes the ancestral lands of the Inuit. I respect the spirit and intent of treaties and treaty making and remain committed to working in partnership with First Nations, Inuit, and Métis people in the spirit of truth, reconciliation, and collaboration. I wish to thank the International Center for Documentary Heritage for allowing me to share some thoughts on the rights of children, international law, and archives. This talk will consider the international recognition of the collective rights of Indigenous peoples, as these ideas are expressed in the policies and practices of public archives and recognized in international law. I will comment on how archives in Canada have been traditionally used in the Colonial project as a conceptual tool for the physical and intellectual disposition of Indigenous peoples. I will then consider how the UNDRIP, without once using the word archives in its 46 articles, has changed the foundations on which public archives practices are built, and how public archives address issues of human rights. Finally, I'll conclude with a look at how the archives of the NCTR is beginning to move archives into a new conceptual space that recognizes and enshrines expressions of social memory that hold enduring values for Indigenous communities. This new model archive recognizes the rich and diverse practices of Indigenous social memory, the ceremonies, artwork, regalia, and oral histories, as holding enduring values for future generations. Our role as archivists is to implicate Indigenous knowledge methods to preserve and share these social memories in a manner both respectful and meaningful for both Indigenous peoples and Canadian settler society. We are trying to braid the formerly unrecognized inherent humanity of Indigenous peoples into the houses of memory of colonial nation states. The UN Declaration on the Rights of Indigenous Peoples is a revolution in legal thought. This revolution is translating into new practices at the level of recorded information. I'm not the first person to identify the UNDRIP as a kind of revolution. The credit should go to James Hackey's Youngblood Henderson, one of the Indigenous scholars who spent years actively campaigning for the UN to recognize the UNDRIP, which he had contributed so much to writing. Henderson's article, titled "The Art of Braiding Indigenous Peoples' Inherent Rights into the Law of Nation States," is a benchmark in our understanding of the UNDRIP and its revolutionary implications. I will unpack this profound article to understand the legal revolution the UNDRIP embodies, describe its implications for inherent human rights, and focus on what this implies for our public institutions of social memory, such as galleries, libraries, archives, and museums. Public archives in Canada currently exist in a conceptual crossroad. Archivists today are confronted with the reality of a judicial system that formally recognizes the same inherent Indigenous humanity that it was originally designed to eliminate. Indigenous society, of course, retains a fair degree of mistrust in this development. This distrust also displays at the level of archival practice. The social memories that speak the truth of Indigenous identity are not addressed in our contemporary archival discipline. In this classic archival perspective, minority expression, immanent or inherent social beliefs, and unique understandings of humanity are understood through the conceptual parameters of a juridical system implemented by a dominant social order. In theory, society is reflected in the resulting archival expressions preserved and made available in public archives. These are the so-called natural accumulations of archival materials that somehow found their way into the public archives to supposedly reflect in an impartial manner the incumbent social order. We know this now to be untrue. So how do we attend to this uneven archival record? To bring together traditional European archival practices with Indigenous traditions of community memory, one must first recognize the colonial history of public archives in Canada. Since the close of the 19th century, Canadian public archives have been deeply embedded in the cultural, governance, and legal agenda of settler society. Canadian public archives served as a kind of documentary armory in the colonial project, preserving the textual evidence to enshrine, conceptually and legally, the settler fact. Every nascent settler event, real and imagined, represented a source of coveted heritage. Cultural authorities placed great value on the pedestrian milestones of early settler existence: the first elementary school, civic festival, and jail. The acquisition programs of Canadian Public Archives form the memory component of a greater colonial equation. Over-informed with the settler's perspective, we have created imperial archives at the cost of a more complete and inclusive colonial narrative. In effect, colonial archives became the documented resources for the conceptual dispossession of inherent indigenous identity. The impetus to address this archival imbalance can be traced to the international activism of indigenous leadership. Since first contact, indigenous peoples have expressed well-reasoned arguments against European principles of individual rights, which silence the collective rights of indigenous communities. There is an ongoing and consistent indigenous vision of human rights that finally broke through as an expression of legal thought in the UNDRIP. This line of thought argues there is an inherent collective indigenous humanity constructed on a latent normative social order. It is expressed in distinct and diverse knowledge systems, languages, and laws constructed over thousands of years. Through this iterative process, humanity has related to nature and society as creating an inherent or sacred order. Human rights are related to this Eurocentric concept of law as an immanent or inherent order, an intelligible and justifiable scheme derived from either an order pre-existing in nature, a discovered divine relation, or a constructed social or cultural life that produced sacred laws and legal doctrines. This leaves us with two views of law: legal doctrines as founded on the latent normative order, and law as the will of the sovereign. These are incompatible. The Eurocentric legal tradition of the imposed order of a sovereign has never been able to exclude the immanent or sacred or customary law. These residual laws have resulted in several legal revolutions or transformations in the Eurocentric legal tradition. Before I go into the conceptual revolution embodied in the UNDRIP, I wish to cite two examples of the sovereign will implicated in Henderson's inherent social order. The first are the comments of the 19th century jurist John Austin, commenting on the common law legal weight of custom in his well-read textbook in English common law titled The Province of Jurisprudence Determined. In an often quoted section, Austin wrote, "At its origin, a custom is a rule of contact which the governed observes spontaneously or not in pursuance of a set of law by a political superior. The custom is transmuted into positive law when it is adopted as such by the courts of justice, and when the judicial decisions fashioned upon it are enforced by the power of the state. Before it is adopted by the courts and closed with the legal sanction, it is merely a rule of positive morality." It is not difficult to sense from Austin's 19th century common law perspective the marginalization of indigenous custom as local law and mere positive morality. My other example is the Cowichan Petition, thought to be the first official document in Canadian history to make the argument for Aboriginal rights and title written in common law formality. The Cowichan Petition was written by lawyers Clark and O'Meara in 1909 under the direction of Cowichan elders from Vancouver Island. The document was sent to the British Colonial Office in London, the provincial British Columbia government, and the Federal Department of Justice in Ottawa. This document influenced the similar Inishka Petition of 1913, which eventually led to the vital 1973 Calder Supreme Court decision. That decision is generally thought to be the dawn of the modern era of Indigenous activism on rights and title in Canada, and signal the recognition of the progress of Indigenous rights on the international stage. There was no other time before the 1960s that Indigenous peoples were closer to forcing Canadian courts to adjudicate the land question than the 2 years between the presentation of the Cowichan Petition in spring of 1909 and the Dominion election of 1911. Prime Minister Wilfrid Laurier had planned to address the issue, recognizing the elders' valid legal initiative, and was even planning to take BC to court to try their land title position, but he was defeated in the federal election. The copy I'm displaying was sent to the provincial government and accessioned by the BC Archives, where it is now available. It is important to note that this is, again, the authority of the Crown determining the avenues of acceptable protest for Indigenous peoples to argue for rights. It was not long after the Cowichan Petition that an article was added to the federal government's Indian Act, making it illegal for Indigenous organizations to raise funds for legal representation to make claims for rights. Most notable for my argument, however, is that the Calder decision of 1973 turned on the idea that local custom and law could be admitted in court as proof of Indigenous rights. 62 years later, the inherent Indigenous rights argued for in the Cowichan Petition and expressed through local custom were tacitly recognized by the Supreme Court of Canada, and they are now enshrined in the UNDRIP. This brings me to the revolutionary breakthrough of the UNDRIP. This UN Declaration builds on a structural latticework of post-war international statements on human rights. Notably, the UNDRIP's Article 3 draws from the first article of the two 1966 UN Covenants on Human Rights. These are the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. These two covenants expand on the 1948 Universal Declaration on Human Rights. The covenants continue to elaborate on the international legal trajectory of highlighting human rights over state values begun in 1948. The covenants are a breakthrough in that they forcefully introduce human rights as a judicially cognizable and enforceable entity in court. They also forcefully advocated for collective self-determination, a core issue of the indigenous rights movement. Through the covenants, indigenous representatives expanded on the contemporary distinction between peoples holding the right of self-determination and minorities holding the right to cultural integrity. Indigenous representatives in Canada recognized in these thoughts the potential for their own struggles for recognition and supported the development of the Universal Human Rights Program, predominantly through the UN, as a remedy to assimilation and racial discrimination. While resisting the domestic indigenous assimilationist projects that first grew out of the post-war international claims for human rights, for example the infamous White Paper of 1969, indigenous peoples formulated their own arguments tying together the mid-20th century rights models for self-determination, minority, and human rights. The covenants influenced national discussions on indigenous rights in both legal and political spheres. In part, this was due to the ongoing campaigns of indigenous representation. Canadian public discourse absorbed the growing contemporary international human rights consciousness in its public policy dialogue on indigenous rights. International forums on indigenous rights influenced the tone of such domestic work as the Constitution Act of 1982, which recognized existing indigenous rights, and the Canadian Charter of Rights and Freedoms. It also informed the arguments of activist political litigation law that enabled the indigenous rights campaigns in Canada. Ultimately, as a remedy for assimilation, the international indigenous rights movement made effective use of the post-war movement towards pan-statist collective human rights. The first article of both covenants reads, "All peoples have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development." Article 3 of the UNDRIP reads, "Indigenous peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development." So the influential weight of these covenants is clear. The idea of inherent human rights is an entirely new frame of reference in the history of Eurocentric legal thought and tradition. It has, since the covenants, been confirmed in several important international documents. These include, inter alia, Jose Martinez Cobo's 1982 breakthrough publication, quote, "Study of the Problem of Discrimination Against Indigenous Populations," unquote, published through the UN Special Rapporteur. Second, International Labour Organization's Convention No. 169 on Indigenous Tribal Peoples, published in 1989, the UNDRIP in 2007, and the Organization of American States Declaration on the Rights of Indigenous Peoples. Notably, this includes commentary on the jurisdiction over colonial grave sites of Indigenous peoples. These developments in legal thought do not underplay the accomplishments of Indigenous activists who have for generations argued for their collective inherent human rights as Indigenous peoples. The inherent rights expressed in the UNDRIP exist as a holistic reflection of the elusive implicit order of human life and behavior developed by Indigenous thought and law. As Henderson notes, in the history of Eurocentric legal thought, inherent human rights have existed as a shadow realm that reveals and reflects the concept of law, both as an immanent order and as the will of the sovereign. And like other legal revolutions, such as the French and Russian, the memories of these radical developments are reflected in public records. In this case, the Indian Residential School Settlement Agreement, which assigned the Truth and Reconciliation Commission of Canada the mandate to research the history and legacy of the residential school system in Canada, and to create a unique set of records to be preserved as a publicly available Indigenous research centre. The Canadian residential school system operated for well over a century with the mandate to forcibly assimilate Indigenous children and eradicate the Indigenous identity of Indigenous communities in Canada. For its investigations, the record-keeping instructions for the TRC included A. Acknowledge residential school experiences, impacts, and consequences. B. Provide a holistic, culturally appropriate, and safe setting for former students, their families, and communities as they come forward to the Commission. C. Witness, support, promote, and facilitate truth and reconciliation events at both the national and community levels. D. Promote awareness and public education of Canadians about the IRS system and its impacts. And E. Identify sources and create as complete an historical record as possible of the IRS system and legacy. The record shall be preserved and made accessible to the public for future study and use. Unfortunately, this TRC did not assign adequate care to the archival role bound into the research mandate of the TRC. The instructions were simply to create as complete as possible a documentary set of records. To be clear, this TRC was not a judicial commission. It did not have the power of subpoena. It could not produce an injunction to appear in court before a tribunal. The goal of the commission was to document the lived experience of survivors at residential schools. It was a victim-centered, truth-seeking commission, and the commission relied on the voluntary offering of the statements of survivors to begin a process of healing, reconciliation, and revitalization. The NCTR has chose to create a decolonizing archive in fulfillment of its mandate. The qualities of such an archive include 1. To recognize the embedded colonizing role played by traditional colonial archives. 2. To acknowledge the overlapping multiplicity of rights, provenance, and the diverse meanings embodied in the archival document. It recognizes that archival evidence is not a fact, it is a matrix of relationships. And like all relationships, it is vulnerable to trust and mistrust, good faith and manipulation. 3. It is a living archive, a place of gathering and participation. It does not preserve static records frozen in time, but recognizes their dynamic, evolving intergenerational meaning for communities and individuals. 4. It provides a social memory infrastructure that supports Indigenous cognitive practices, Indigenous knowledge methods, and social protocols. 5. It breaks out of the textual paradigm of archival evidence. It will build on the digital potential to interrelate diverse genres of social memory to create a holistic center of social memory, recognizing the spiritual and environmental in the context of local social sanction. And 6. It offers a safe and accessible space for Indigenous peoples to learn of and freely express their views on the legacy of the residential school experience, and for such a society to listen, encounter, acknowledge, and reconcile. Within the framework of the UNDRIP and its Indigenous vision of governance, rights, and identity, the NCTR is attempting to decolonize a profoundly colonized history. Unstated in its mandate, the NCTR creates a new conceptual space where the holistic and immanent orders and values of Indigenous communities can grow uninhibited, to cross-pollinate with the rational, individual enlightenment principles of European social thought, and to seed hybrid ideas of immanent order and mutual esteem, to freely grow a colorful garden of collective and individual rights, unhindered by centuries of imperial judgment. To say I see you, I hear you, and I begin to understand. For ultimately, we are what we choose to remember, but we're also what we choose to forget. Thank you. Merci beaucoup. Kinyanis Komatim.